Proposition 8. We believe the court got it wrong on these rulings. The court's activist ruling on the Defense of Marriage Act ignored the votes of a bipartisan majority of Congress. This is a dangerous precedent which strips power away from Congress with respect to defining national marriage policy. We must work to defend the rights of Americans to make marriage policy. Additionally, the Proposition 8 ruling is a loss for the millions of Americans who have gone to the ballot box to voice their support for marriage between one man and one woman. California's governor and attorney general who refused to defend the people's wishes abandoned the people of California. It is a loss for democratic self-government. With the Supreme Court denying them standing, they have left the people voiceless. While California has silenced the voices of their citizens, the Supreme Court has not created a constitutional right to same-sex marriage. 38 states have affirmed the belief of their citizens that marriage exists between a man and a woman and is a necessary building block of stable society. The debate over marriage will continue, with the states leading the way. We must work to defend the rights of Americans to make marriage policy. We should work to promote the truth of marriage between a man and a woman. It is wise policy to uphold the reality that every child deserves a mom and a dad, and society as a whole benefits when they do. And now we have some statements by some of our other members here. First, we have Steve Scalise from Louisiana.
Thank you, Vicki. It's a sad day when unelected judges change the definition of marriage and turn their backs on the will of voters and their elected representatives who have made it clear that we want to continue to maintain the tradition of marriage as the union between a man and a woman. And far from resolving this issue, all that this ensures is that now the definition of marriage will be fought out in courtrooms by unelected judges as opposed to state legislatures and here in Congress where ultimately elected representatives instead of unelected judges should be making those decisions. So the issue is far from resolved, but unfortunately it creates a lot more chaos than we had before the DOMA law that was passed by a bipartisan coalition of Congress was in place.
I'm John Fleming from Louisiana. I'd just like to comment first on marriage itself. Marriage is a fundamental building block of our civilization. It precedes this nation itself. It's the fiber that keeps our civilization so strong, and certainly it's the ideal model from which we raise children. That is, a marriage bond between one man and one woman. With regards to the issues at hand, today's decisions, I agree. I think that the Supreme Court got it wrong. It's surprising that the Supreme Court, in the case of Obamacare, a bill that was passed purely on a partisan basis, unpopular, and somehow the Supreme Court had to make that constitutional. In the case of DOMA, the Supreme Court bent over backwards to find a way to make it unconstitutional, even though it passed on a bipartisan basis and has been very popular. The good part about DOMA that we find is that the 38 states that currently do not recognize anything but traditional marriage are not forced to recognize anything that they themselves do not, through their own laws, deem to be appropriate marriages. So this is, I think, a good starting point to work from here. Thank you.
This is a great day for America. 10 years ago today, the United States Supreme Court in Lawrence against Texas took the first important step to guaranteeing that all Americans, regardless of sexual orientation, were equal citizens under the law. Today, the United States Supreme Court, in two important decisions brings us that much closer to true equality. In the decision striking as unconstitutional the so-called DOMA, or defensive marriage case, the United States Supreme Court held that there was no purpose for depriving gay and lesbian couples of the right to marry the person they loved. There was no legitimate justification for that. As Justice Scalia noted, that the Supreme Court could not reach the merits. But everything that the Supreme Court said in the defensive marriage opinion, where they did reach the merits, demonstrates that when that case finally does come to the United States Supreme Court on the merits, marriage equality will be the law throughout this land. Our plaintiffs now get to go back to California and, together with every other citizen of California, marry the person they love. And the next step is to translate the promise, and it was reaffirmed today in the DOMA case, that every citizen in every state has the right to marry the person that they love. The Supreme Court's decision on standing is important for another reason. When we started out in this case, we said we were going to prove three things. We were going to prove that marriage was a fundamental right, and the other side accepted that. We said, second, we were going to prove that depriving gay and lesbian citizens of the right to marry the person they love seriously harmed them and seriously harmed the children that they were raising. And even the opponents agreed with that. And third, we said we were going to prove that allowing everyone to marry the person that they loved, regardless of sexual orientation, did not, could not harm anyone. And not only did the proponents on cross-examination have to accept that, but today the United States Supreme Court said as much, because they said the proponents have no concrete injury. They cannot point to anything that harms them, because these two loving couples and couples like them throughout California are now going to be able to get married. And so this is a wonderful day for our plaintiffs. It's a wonderful day for everyone around this country, and in California in particular, that wants to be able to marry the person that they love. But it's a wonderful day for America, because we have now taken this country another important step towards guaranteeing the promise that is in our Constitution, in our Declaration of Independence, that all people are created equal, that all people have the inalienable right to life, liberty, and the pursuit of happiness. So this is a great day. We thank the Supreme Court. We thank all of you. And perhaps most important, we thank all of the people who have devoted so much to this battle over so many decades. People who did it at a time when it was not as easy as it was for Ted Olson and myself to go into court. The only thing I regret today is that my friend and colleague Ted Olson can't be here. He has been a leader in this battle for the last 4 years. He is unfortunately today in another court, in another part of the country, arguing another case. But his spirit is here, and he will be with me tonight, and we will celebrate, because this is a victory not just for us, not just for the plaintiffs, not even just for the people who have worked for this so many decades, but for all Americans. Thank you.
The title of our episode today is One Step Forward and Two Steps Backward. That is what has happened when we look at the unconstitutional decision on DOMA, Defense of Marriage Act. It was unconstitutional at the time. I recall writing a paper on it. And also the case out of California. And you heard about that and what happened there, and the history recited by attorney David Boyce. David Boyce acted on behalf of the people affected in the state of California. Jerry Brown was the attorney general there, and of course now the governor, did not defend the Proposition 8. What had happened there was the citizens of California had voted there on so-called same-sex marriage and had approved it. Then came Proposition 8 that some people were, in my opinion, tricked primarily by the Mormon Church. And that was in 2008. Of course, President Obama was running for election there. And we had some reactionaries within the African American community, in particular minister types, that persuaded African American voters to vote for Proposition 8. Thus, there was a long legal struggle there, and Proposition 8 was ruled unconstitutional by the Ninth Circuit. Now the case has been remanded back to the Ninth Circuit to dismiss the lawsuit. So thus, in the state of California now, all people will be permitted to marry. So unfortunately in 2013 we've come to this point. But what has happened, and we'll let David Boyce talk about that, effectively they will return to the Supreme Court at some time in the future, and then the national laws against same-sex marriage will all fall because they deny equal protection of the law. There's no doubt about that. So that is the one step forward. The two cases decided today in a totally different manner. Now, prior to that, the voting rights case known as Shelby out of Shelby, Alabama, known racist place versus Holder, Shelby versus Holder. The Supreme Court struck down Section 4. Now, what has basically happened here? The Congress will have to go back and redo that particular item, and we're in a situation where things are increasingly polarized. It passed in 2006. It's reauthorized. That's the Voting Rights Act. Now it's almost 50 years later. We're in 2013, 14, and 15. John Lewis and various others spoke on that, and you will hear that after us as we fuse together these two very important events. One step forward and two steps backwards. What has basically happened here in the voting rights case where it was shredded, that compels states to get pre-approval. The states that are under the Voting Rights Act, Texas and various others, we talked about it yesterday, parts of New York, and some other states. But it involves the voting rights of African Americans, Latinos, and Asians, and they all spoke, and you will hear that about the importance of it. But one thing to remember in this particular Congress, back to that, it is polarized. Could not even reauthorize the deficit ceiling. So you have a situation, and Texas knows that. You can take the case of Ms. Davis down in Texas. She's a state senator. She successfully filibustered a reactionary abortion bill. Now, this is part of what they call the social issues. That is the only reason that is brought about. That's to keep these Neanderthals, as they say, in that particular and active. Because after the social issues fall apart, the Neanderthals will disappear. And as LBJ was so fond of saying, anyone who's been to a goat roping contest knows that. And that is the reason for this. Now what happens is, in the Voting Rights Act, the two steps backward, there will be increasing pressure on the Congress, as John Lewis says, to redo the model of a composition. Now, what Roberts said, and now one thing to remember, Roberts is like Justice Tierney of Plessy versus Ferguson. His great-great-grandfather was in the Civil War.